again, thank you all for joining today to the continuing series of Ben webinars. For those who might be new to the series, why do we do this? We feel we have a very positive connecting role within the Philadelphia ecosystem. And Ben is very pleased to bring in speakers on topics we feel are very relevant, especially to the entrepreneurial community. So we've done this over the course of COVID. We're very pleased to bring in some great speakers, and I think very, very relevant topics. And hopefully, the number of registrants today, show us that this is certainly a topic that captivates a lot of people's interest. So again, thank you. Rules of the webinar, before I turn it over to Cynthia, is that we are recording this webinar. So just to let you know, we are recording. Second thing is regarding questions, we will have a number of people in this webinar, and as a result, it's probably better to ask questions via the chat function. I can introduce Kate and Nicole of Ben Franklin on the Zoom call. They'll be helping us, receive the chat questions. And depending on the flow of the webinar, we might interrupt, Cynthia with important questions at the time, or kind of wait until there's a little bit of a lull or at the end. So we sort of play the questions by ear. So if you if you use the chat function and we don't respond immediately, just hang in there. We will get to you. So those are sort of the housekeeping items to start off the meeting. Let me just introduce quickly Cynthia, and you can add some things that I won't add in this quick introduction. But we're really pleased today to attack this topic of intellectual property, and actually some of maybe the mistakes that people make early on that can be easily avoided. And I think Cynthia's going to guide us, especially around entrepreneurs who don't have a lot of money, don't have a lot of resources, what they might really do to avoid making some substantive mistakes as they try to grow their business. Cynthia has been in her notes, she's been practicing tech law for over 20 years. So she started when she was 13 or 14, I guess, I'm not sure. But she was doing this amazingly 20 years. She's the director of the Detkin Clinic at the University of Pennsylvania Law School, and she can introduce that. But it's really fascinating because it really is, as she mentioned in her email note, it's kind of a teaching law firm. And so I don't know if I still remember back in the days I was in graduate school, I used to go to the dental school within campus because they had sort of a teaching dental clinic. That was one way you could certainly get dental care within the university. So this is kind of the equivalent of a teaching law firm within the university, and she can explain that in a little more detail. Because of that, she encourages companies and entrepreneurs to reach out and have engagements with her class, which is this teaching law firm, at no cost to the company. So it's a great resource within the Philadelphia region to have the Detkin Clinic and Cynthia leading it. These obviously tend to be timed with the semester because obviously students come in and they depart her class. So she did want to mention that as class starts next week, if you're a company that's looking for potential help around legal issues, please contact Cynthia. She said as of the end of Friday, because you have to start assigning your student teams to companies or entrepreneurs very quickly, and that might be in the middle of next week. So if you are a company or an entrepreneur that might want to take advantage of this great resource, don't hesitate. Please reach out to Cynthia and voice your possible interest in taking advantage of her classes and the resources. If you missed the fall window, I think as normally would suggest, December would be the next time that to be inviting applicants to come in for this program. The last point I want to make is Cynthia mentioned that she does some office hours. There's going to be two, one in the week of October 18th and one on the week of November 15th. And she does these office hours and sort of consulting with her teams and herself. And this is conducted at the Brick Center at the Free Library of Pennsylvania, Free Library of Philadelphia. So between now and December, if you wanted to reach out to Cynthia, you can certainly do it through some of these office hours they have in this October week and November week. So I've taken enough time. I'm going to leave it off to Cynthia. She's going to take over the screen and get prepared what I think is going to be a really intriguing webinar this afternoon. So Cynthia, thank you so much, and you got the comms.
Fabulous. Thank you, Mark, so much for that gracious introduction. And I just, and I want to also thank Kate and Nicole for all three of you for inviting me today, talking about this topic. And I just want to say, I love the work that Ben Franklin does with the Philadelphia tech community and with our ecosystem. And I've really valued our partnership and have worked with you for the past 10 years. And so it's delightful to finally actually be here and to be able to address these topics with all of you today. And I do want to encourage you. Nobody wants to hear me speak for 45 minutes. And so I would really, really encourage you to please ask questions, make this presentation relevant. And so thank you for keeping an eye on the chat and for calling the questions to my attention as they come in. I appreciate that. Okay, so when we first talked about doing this presentation, we talked about the top 10 mistakes of tech entrepreneurs, and I decided to spin it a little bit more positively and talk about maybe, although I'm calling it top 10 mistakes, let's talk about the lessons that we have seen entrepreneurs learn while working with them, and hope that we can pass on to you. Can you see my slides, Mark? Okay, fabulous. Okay. As Mark said, the reason I'm here to talk to you today is because I've been working with entrepreneurs for all of my career. And right now I'm helping to run this IP clinic. And right now, when we are back in person, this is where we are physically located on the corner of 34th and Sansom. But right now we're actually doing all of our client counseling remotely. And this presentation will be passed on to you. So my email is on this slide, and the website for the clinic is on this slide as well, if you'd like to check us out and see if we could potentially help you this semester or in the future. Okay, so let's dive into the lessons. Okay. So the first lesson that we talk to all of our entrepreneurs about is there's not endless money for a tech entrepreneur. And so we help them to figure out how to be strategic and intentional. So what do I mean by that? So we can't patent everything. We wouldn't have the money to patent everything, even if we could, and not everything that a tech entrepreneur invents is patentable. So we ask them to sort of frame this way, to not think about the patent as an end in itself, but as a means to an end. Start thinking about connecting the IP strategy to the business purpose of the company. And what I mean by that is to think about your competitors and where you are situated in the market. What makes you faster, cheaper, better than the competitor? Or a different way to think about this, what must your competitor do in order to compete well with you? And that's where you should put your army. That's where you should put your money and your arsenal. So we think about this in terms of what is your secret sauce? What makes you faster, cheaper, better? Or what must they do? What's the gating thing? What must they do in order to compete better with you? And then we think about what tools we have, to actually protect whatever we've identified. We should be having these discussions early on in the process. Why? I'll talk a little bit about that in a second, but basically you can lose some of your rights if you wait. And so we want to make sure that if you're going to be strategic about, say, not filing a patent, that you make that decision. You're not forced into making that decision because you've waited too long and you've lost your rights. Why else should you be thinking about these questions early and often? Because it allows you to budget, and because it allows you to sort of set priorities and may open doors for you down the road. There are lots of reasons to patent, as you well know. One is, of course, defensive, so that your competitor needs to pay you if they need to practice your technology. But it also is an indicator, of course, to funders that you've got something valuable. It can be a bargaining chip that you can use. If you are potentially infringing someone else's patent, then maybe they are also infringing yours. And so it can be a negotiating or a bargaining chip. It can open doors for you down the road. So we talk to our early stage entrepreneurs about all these strategic reasons to apply certain IP tools. And best, of course, if we can have those discussions early. And something else that we tell them in terms of being strategic and intentional, everybody goes straight to patent. I need to get a patent on my whatever. Sometimes patents, as I've said, are not the right solution. Maybe if you're moving quickly in a quickly moving market, by the time you get that patent, it's not actually going to be helpful to you. Or maybe what you have invented is not patentable to begin with, or maybe you don't have enough money to enforce that patent. And a patent, is not very valuable if it's just a piece of paper hanging on the wall. You need to have the money to actually back it up. And so if you don't intend to potentially go to court with this patent, we might want to think about whether or not you spend your money that way. The good news is that patents are not the only answer. They provide great, strong protection, but there are other tools in our arsenal that we can apply. We can talk about copyright, we can talk about trademark, we can talk about trade secret, and we can contract. And so by sort of being methodical, intentional, and strategic, we can craft a holistic IP protection strategy for entrepreneurs. So that's lesson 1. Any questions on any of that? Okay, good. Let's move on to lesson 2. So flip side, you have had all of these discussions with your counsel, you've been strategic, you've implemented, and what happens? A year passes, the market changes, your ideas change, your business goals change. Change is okay. Just because you've spent money to file a patent doesn't mean that that patent may end up making sense if you have strategically moved. So just because you have spent money, don't throw good money after bad. So one of our second lesson here is that change is okay. Potentially, you really loved a trademark last year. You've changed your product, the trademark doesn't make any sense for you anymore. Or someone else, a competitor, has entered the market and they're using a very similar trademark. Maybe you want to rebrand or you want to sub-brand. That's okay. So when you add new trademarks, consider your use of the old trademarks. And if you're not using them anymore, let them go. Because just because you've spent the money in the beginning, you have to continue to spend money to keep these rights. Patents, for example, you pay annuities. Patents take a long time to issue and you have to answer office action. That takes money. If it's not right for you to continue to invest in that particular strategy, it's okay to shift and change. You should be coming back to your IP strategy at least yearly, thinking about what's still necessary, what more you might want to do, whether your IP tools are actually still granting value to you or not, and talk through that with your counsel. Related to what we were talking about with patents, this is a really important lesson that a lot of our entrepreneurs have learned the hard way. If you disclose your IP, you disclose your IP, you sometimes will close yourself out of the ability to protect it. And what do I mean by that? So I know that early stage entrepreneurs are facing attention. They have to tell certain people about what they're coming up with, or else they won't get funding, or they won't get partners, or they won't, hire people. So you definitely need to disclose your ideas. But yet, I'm telling you that if you disclose in the wrong way, that you can cut off or curtail your ability to protect what you've invented. So you have to only disclose strategically and intentionally again. If you disclose before you have patented, you start a time clock running in the United States for your ability to file a patent. Right now, that grace period is 12 months. So if you disclose, then you only have 12 months to get a patent in the United States. If you disclose, you actually, if you want to file a patent overseas, keep yourself from filing a patent, being able to file a patent at all in certain countries. And so you have to be extremely careful, especially if you want to protect your IP overseas. Trade secrets, whole other question. Trade secrets are only protectable as long as they remain secret. And so if you disclose what you later want to protect through trade secret, you can't protect it through trade secrets anymore, because trade secrets all have to continuously be subject to what the courts say is a reasonable effort to maintain secrecy. So how do you protect yourself so that you keep doors open for later IP tool application? One way is to use non-disclosure agreements or confidential disclosure agreements. CDAs and NDAs are roughly the same thing. They can help. So I would imagine that this audience has all seen an NDA before and knows what an NDA is all about, but basically to review, or if you've never seen one before, there are various components that are critical for an NDA. Disclosing the parties that are subject to the terms, the purpose to which that information is going to be used, what you're going to allow them to use and how it's going to be used, what's the information covered, and how long not only is the agreement going to last, but is the obligation to keep confidential going to last? And those are different concepts. So for example, you might have a 1-year term on the NDA, which means that anything disclosed within that 1-year term is covered. But there may be terms in the agreement that say anything that's disclosed within that 1 year must be kept secret for 5 years or 2 years or forever if it's going to be a trade secret. So that's what we call a tail. And so there's both term and tail. Okay, so that's those are the components of a decent NDA agreement that you should be looking out for. NDA agreements, CDA agreements can be one way or two ways, meaning that one way would mean that whoever you're disclosing to needs to keep your information secret, and that's it. Two-way, they're going to share information with you, you're going to share information with them, you both have an obligation. Obviously, one way, the right way, is better for you as a party because you're not bound to any obligations, they're bound to obligations. So one way if that's possible, two-way if necessary for an NDA. Okay, what else besides an NDA? You should also make sure, disclosure-wise, to protect you, that you have corporate policies in place. That means that your employees are also bound to keep your information secret. And if they go to another competitor, to another company, they're not allowed to bring that technology or reveal that technology. So make sure that you are also protecting yourself from disclosure by having corporate policies in place or employment agreements. NDAs are not always practical, as you know. If you're talking to a funder, they're going to laugh at you if you bring an NDA with you and have them sign an NDA. So if an NDA is not practical, to avoid disclosure problems, speak in generalities to the best that you can, or file a provisional patent as soon as you can before you go and you disclose, and think hard about where your value resides. Because if basically you're only going to be trying to protect an algorithm that's sort of deep within your technology, you can speak about what the technology does without revealing the critical part that can't be disclosed. So sort of goes hand in glove with speaking in generalities. Sometimes, remember I said watch disclosure, sometimes disclosure is strategically wise, or at least strategically, it's part of your strategy. We call this the poor man's patent. Basically, back to what I said about not being able to patent if you have disclosed. Other people also can't patent something that has been disclosed. So if you know that you're not going to patent, you can ruin it for everybody else too by disclosing. You have to be careful about that because you have to make absolutely sure that you don't mind that your rights are being, waived basically. And you want to disclose publicly and in detail if you want to make sure that other people can't patent, what your invention is. But sometimes disclosure is used as a strategic tool. So that's why this lesson is watch disclosure. I'm just saying be intentional about it and know what you're doing and don't inadvertently ruin, any rights that you want to save.
Cynthia, there was a question about, is there a legal definition of disclosure? I mean, you can hint at something versus, just blabbing it all out. And where do you cross the line and say, oh my goodness, I actually disclosed it versus kind of speaking in generalities, as you mentioned?
Great question. I think the first step is to think about what makes you better, cheaper, faster? What is the value proposition? What is the thing that you want to keep protected? And if it really is, again, that algorithm that's sort of deep within, your code and your technology, you don't want to reveal that algorithm, but you can talk about the results of the algorithm, and that's okay. If you talk about it sort of on a high level, something that could not be patented because it is too general or is not disclosed in enough detail, which is a requirement for patent, it's okay to disclose that. So it will depend. There is no definition of disclosure because it really depends on what the art is, right? Depends on what the technology is.
And would that change? I was going to say, would that change for a physical embodiment? Obviously, an algorithm, that would not be in the public domain at all, probably. But if you want to make and sell a physical product, where does the disclosure then, approach the line?
Great question, because I think what you're also saying is something that I should address, which is that disclosure does not have to be oral. If you're thinking about like disclosure being in a meeting or something written that you send, a document that you send, yes, those are great examples of disclosure, but disclosure is also offering to sell or selling something. And so even if you're not talking about it, if it is available and other people have been able to, hold it, see it, know about it, that is also disclosure. So disclosure, sort of legal definition of disclosure is all of that. Has the outside world been able to assess and evaluate your technology? And so you have to also be careful about those things as well. Now, I worked for a company before I came to Penn, and we had a question about whether or not we had disclosed something. We had sold the product, but the product was not easily reverse engineerable. And what we wanted to patent was really, really deep in the product. And after a lot of back and forth, we determined that we had not disclosed it because although it was for sale, we hadn't actually sold the technology. We had sold a product that incorporated the technology, but nobody knew how the technology worked yet. And so it was still deemed to be not disclosed. But you don't want to get into a situation where in court, you are arguing about disclosure or not disclosure by pulling out your documents and trying to, redo your notes and prove that you didn't disclose. You just want to be careful on the front end that you don't have to have that battle. So there is no definition, but watch your disclosure and be mindful about who you're telling what to. So does that help the question?
I think so, yes.
Good. Okay. Any other questions before I move on?
We're good right now.
Okay, great. Thank you for the question. Okay, we have seen a number of entrepreneurs get in trouble with this. Be careful when you are working with encumbered IP. And what do I mean by that? IP that has been promised already to somebody else. And this comes up, I have seen it come up in at least two scenarios. First of all, when people are doing business with a university employee, because all university employees have requirements to assign their technology, their inventions over to their employer. And so a university employee may not understand that or remember that or know. And I can tell you that the default when you're working with any university employees is for them to say, nah, the university doesn't own this. This is something I came up with. Because of course, these are bright people that are, they're working in their field, and everything that they come up with, they see the value in it, and they may not know, or they may not want to think about the fact that what they are inventing is probably already promised to the university. At the very least, if you're working with a university employee or somebody that's affiliated with the university, like a student, postdoc, any faculty member, you need to at least acknowledge, go to the university and get a waiver. which is something that universities do daily. They evaluate whether or not they really own certain technology or want to take an interest in certain technology. Even if the university owns it, they can give a waiver that basically says, we do own it, but we don't care about it. It can be yours. You can patent it. But you just have to be careful whenever you're working with somebody that, that is affiliated with the university. Second, we've seen entrepreneurs get in trouble with a former employee of potentially a competitor, that comes and works for you. They may say, I don't remember signing away any rights, or I'm under no contractual obligation to not reveal something. We talked about on the other side, when you're washing your own disclosure, that you have to make sure that you button down your employees. Well, this is the opposite side of the same coin. If you get an employee of a former employee of a competitor to work with you, they may have some contractual requirements that they may not remember that they signed about trade secrets or about non-competes. And so you just have to be very careful when you're in the hiring process and after you hire them, as they can start to work with you, that none of what you are developing is owned by contract to by someone else. So just be very careful, especially if you are in a small market where there are very few companies that are chasing the same sort of product. Be careful about some of these contractual obligations.
Cynthia, going back, there was a question about on NDAs. I think rather than the obvious, if someone had confidential information and disclosed it with ill intent, maybe we could all think about that. But what happens if someone signed an NDA and did an inadvertent disclosure of confidential information? So there's no nefarious, no nefarious intent. It was just inadvertently they broke the confidentiality mandate they signed. What happens, and what's the ramifications of all that?
So I guess it depends on on what was disclosed. But if the person inadvertently disclosed it, they are technically in breach of a contract. And to the extent that there are damages that result from that breach, they could be in trouble. So what should that person do if they inadvertently disclosed? I think they probably should especially if it's something important, they should probably go back to the party that they contracted with and say, I inadvertently disclosed this, but here's what I've done about it. I've pulled it back. I sent an email and I shouldn't have. I immediately contacted the other party. I asked them to delete it. Here is the other party. Basically, these are the steps that I've taken to ameliorate it. The party that owned the confidential information would probably want to know what happened to it, particularly if it's a trade secret, because they have to shut that down immediately, or else their whole trade secret protection, is shot. So I think inadvertent disclosure happens. People make mistakes. But to limit your liability for that, I think that I would try to ameliorate it immediately and then tell the party that owns the confidential information what happened, and work with them to make it right.
All right, thank you.
Yeah. Any other questions? Okay, good. Okay. We see this one all the time, and I know that everybody knows better about this, but I just want to put it on a slide because this is like the number one thing that gets people in trouble. Contract. Why do we contract? We contract because when parties come together, they often don't completely have what we call a meeting of the minds. Everybody's trying to be friendly. We're all trying to move the business forward. We're trying to meet goals. It's really exciting in the beginning and yummy when you're getting together with new partners and you're excited and you're thinking about it. But not everybody may be on the same page. And the reason why we contract is to really uncover these misunderstandings and to deal with them on the front end when everybody is friendly, and to make sure that everybody knows what's expected of them, what should be delivered, who's going to own what, how the money's going to flow. It's much better to talk about these things proactively than to sort of unravel it later and then reveal that people were not really on the same page at the beginning. So there are ways that you could contract with friendly parties. It's not, people think that, even broaching the idea of a contract sort of sours the deal. I think what we tell our entrepreneurs that say things like this to us is that it actually makes you look professional, because people know that you take your IP seriously. People know that you take your relationships seriously. People know that you are in it for the long haul with these partners. This is not just a casual thing that you actually want to, establish a partnership that you want to put down on paper. So my advice is to contract even with friendly parties and when you are friendly with these parties, because that really is the best time to make sure that you're on the same page and, really talk through these issues. Where do we see it? We see it especially in consulting agreements. There's this work for hire term that's thrown around a lot. And actually work for hire is not always used correctly. Work for hire is actually a very small subset of situations. And so just sort of drafting or saying, oh, this is going to be a work for hire, that means different things to different people, and the law may not protect you unless you actually put down in paper what is to happen, who's to deliver what, to whom, for how much money, and who's going to own those rights. If you don't contract, the default is that anyone that you hire owns the IP that they create, even if you are paying them. So to say that again, you hire somebody, they create, there is no contract, they send it to you, you pay them, they still own it. And if you want to file a patent on that later, if you want to file a trademark using that logo later, you don't own that stuff. And so you have to get it in writing, because the default under US law is that anybody that creates owns what they create. And in particular, that document has to talk about assigning rights. The A word needs to be in there, moving the rights from the consultant or the employee to the entity. Just because you say something like consultant will create and company shall own or company will own or whatever, that's not actually completely correct. It actually needs to say consultant will create and consultant will assign, and then the company does own. And so we look at documents like this all the time and help to sort of do amendments and figure it out and fix it. Much better to just do it right the first time. Get a contract, make sure that it's correctly drafted. We also see this with founders. And so when you've got an early stage company, everybody should figure out who's bringing what to the table. How is IP going to interplay with ownership or equity? What happens? You're not going to split up, but what happens if you do? Who's going to take what? And have all of the founders and owners assigned the IP to the entity, because really the entity should be the one that is owning all of the IP. And you have to make sure that all of that is buttoned down and that the individuals don't own it, because if you split up later, you might think that the company owns the IP, but if you never did that assignment, the person that's leaving is taking all the IP with them. So make sure that you contract. This is a good time to actually talk to a lawyer and make sure that everything is buttoned down and stated correctly. But this one is a really important lesson, and we see this again and again with early stage entrepreneurs of all kinds, including tech entrepreneurs. Okay. Any questions about that?
No question about that, but there was a question. This is regarding sort of NDA stuff, and I'll just read it directly. It says, if you hire someone from a competitor and they create a process that helps you compete, but part of it may have been used at that competitor, is that legal?
You would want to look, when you're hiring that person, at their employment contract with that competitor and see exactly what is covered. If they are inventing new things for you that rely on their residual knowledge, like, and part of it could be just their graduate degree, right? Or their experience in the world. Of course, they can create for you. If they're taking something, though, that was sort of defined as a trade secret or was in the contract stated basically as something they were not allowed to use when they left, then you get into a gray area. Courts generally will strike down a non-compete that doesn't allow somebody to continue to make a living, but they do draw a line at things that are specifically determined to be trade secrets of that first company. So it would be just important to look at that contract and to see what the words of the contract said. And then if you are worried about it and you think it's a gray area, that's a time that I think you could reach out and talk to counsel about whether or not this is an overbroad non-compete or whether it would not be enforceable. And then you can make a reasoned judgment about your risk proceeding with having that employee work on that project or invent something for you in that area.
Thanks.
Yeah. Speaking about using the right language, we also see not only do entrepreneurs sometimes not contract at all, but when they do contract, particularly their licensing, they don't always do it correctly or don't understand what their license allows them to do. So first off, let me talk about the difference between assignments and licenses. So assignments are a complete transfer of all rights to somebody else. So for example, that consultant that I was talking about, you would like that consultant to create, and then you would like the consultant to not own any part of it at all. You're paying them, they're creating, all the rights go to you. So that should be assignment. And that's why we use that assign term in consulting agreements. But there's a whole different set of scenarios, right, where you might want to reserve some rights to yourself, or you might want to allow different parties to use different aspects of those rights. And that's where licensing comes into play. You can license dividing by any sort of standard, like the scope. Maybe somebody can use your technology in a certain area, like only related to medical devices, but not related to something else. So you can grant a limited license that is just by scope or by time. Maybe they can use it for a year and then it times out, something like that. Territory, you can divide up the whole world or even parts of the country, in terms of license rights. Or how they're using it related to scope. So basically licensing, you only get partial rights or only grant partial rights. So what does this mean? If you are the licensee, you have to make sure that the license grant that you're getting allows you to do everything that you need to do or want to do in the near future. So you might want to push for something broader if you want to go potentially into other countries. But of course, there's a trade-off for that, right? You're going to be paying more for that expanded scope. But you just have to be very careful to look at the words of the license to make sure that if you are getting those rights, that the rights that you're getting are everything that you need to do, everything that you need to do what you need to do. On the other side, if you are the licensor, and for example, you want to reserve some rights, either for yourself or to grant to somebody else, because you don't think that this particular licensee, has the ability to go into another country, for example, or to, you don't want to have them be able to compete with someone else that you want to do business with. Make sure that you draft to retain the rights that you don't want to grant to this particular licensee. So in summary, license rights are completely controlled by contract. You can contract in a lot of different ways. This is a good time to be strategic and talk to a lawyer about just how to sort of divide up those license rights. And sometimes license rights are not enforceable unless they're in writing. One final thing, if you are the licensee, sometimes you are limited in what you can enforce. So what do I mean by that? If the licensor hasn't granted all the rights to you such that you are the exclusive only licensee, you might not be able to enforce those license rights. So for example, over patent. So if you are the licensee of a patent and somebody else infringes, you may have to go through that licensor to get damages. And that's something that you should think about if you are basing your entire business model around this technology that you're licensing in. You want to make sure that you've got the rights to enforce, so that if ever your value is called into question because somebody else is using that technology, you have the ability to shut that down. And you don't always have the ability if you're not an exclusive licensee. So be careful of your licensing. Make sure that you read the license carefully and draft it to what exactly you need to do with that technology. And if you need to enforce the technology against others, make sure you have the right to do that.
Just a question. This is a personal question. I've seen this on various license agreements. What is the legal distinction between a sole license and an exclusive license?
That's great. A lot of ink spilled on that. What it really turns, so imprecise drafting, they say sole and exclusive license. They are not actually the same thing. So I teach my students not to use that construct. What it turns on basically is whether or not the licensor wants to reserve some rights for themselves. If you are, if you need to reserve it, then it is not an exclusive license. Let me remember this, but that's what it turns on. Basically, if you say that you are granting a sole license, then I think that that means you reserve rights. I always have to look this up again and again, but this is a distinction about whether or not the licensor has the ability to continue to use those rights, or if they are basically giving all those rights to the licensee to the exclusion of themselves, where they themselves cannot use those rights anymore.
Thank you.
Yeah.
Just another question on licensing. I'll just read it directly. If you initially license your IP to multiple parties, how does that later affect your ability to sell that same IP? Can you sell it with parties under contract? Do you have to wait until expiration of the contracts if it's not perpetual?
Yeah. So could you, like, for example, and I think this is interesting too, because like if the company is bought, and you are, if the company is bought out, for example, and all of the contracts are part of the assets, then I would imagine that would be taken care of in an assignment clause of the license, where basically it would say that the license can be assigned by the licensor to another party, and then those licensees basically would have to pay the subsequent owner, if that's the question that you're asking. You have to be, it's a great question, because you have to be careful when you're drafting the license to look at the future about what could happen, not only to the licensee, but to the licensor. Do you want to continue to license to someone that might be your competitor? Maybe you like the current licensee, but if the current licensee considers that license an asset and they are bought out by your competitor as the licensor, do you want to have to do business with your competitor in the future? And if you don't, then you probably should say under the assignment clause that this license is personal to that particular company and cannot be assigned. Now, the licensee is probably going to worry about that, because if the licensee wants to maintain, all options to be bought out in the future, they would like this to be an asset of their company, and they would like to be able to assign this license. And so we actually, in the company that I worked for before I started to teach, went to the mat over the assignment clause a lot, because the owner of my company said, we want to be able to buy and sell you as we want. And you can't encumber yourself, basically, that we have to go back and look at all of these licenses and change the language and renegotiate that because we cannot assign this license. So this is a great question. Licenses are assets and they follow the company. And so if a company is taken over or sold or whatever happens to the company in the future, the license goes with the company unless there is something in the clause of the assignment of the license that says otherwise.
Just a quick comment for some people, we are recording this, so I know people are furiously and feverishly taking notes. It'll be posted on our YouTube channel shortly, so I know there's a ton of information here. You know, you can stop scribbling and look at it multiple times after this is over. So, you know, just a note to everybody out there they don't have to necessarily be scribbling. We'll post this.
Great, and the slides are coming to you too. And I'm happy if I was not clear in something that we discussed or a question occurs to you after the presentation, my email is in the second slide. And so I'd be happy to follow up and answer questions as they occur to you. Okay, we ready to move on to lesson 7? Okay, and there are 10. And so, we're closing in on it, everyone. Okay. Oh my gosh, do we see this again and again? Trademarks. What exactly should you trademark? Do you have to trademark? And if you do trademark, what rights do you get? Trademarks are about branding. And I know everybody knows that, but let me talk about how that plays out with some of the entrepreneurs that we see and what I mean. Trademarks, getting coverage over a trademark, filing a registration for a trademark is not the same thing as protecting your company name and getting a website address. There are 3 different systems, 3 different registries that serve different purposes. And one doesn't really affect the other unless there's some malicious intent involved. So if you really, really like your name of your brand, there are sometimes that brands are also company names, like Coca-Cola is a good example. You really like the name Coca-Cola. You need to think about that not only as your company name, but as your product name, which is trademark. And you probably need to also lock down the internet addresses that have to do with Coca-Cola. There are 3 different registries. We get entrepreneurs come to us all the time and say, I don't need to worry about trademark because I've already filed for the company name with the Department of State. We're good to go. And then we have to remind them that if their company name is the same as their product name and therefore their brand, that just because they've registered for a company name doesn't mean that they've also secured the brand protection. And we need to look at the USPTO website and see if somebody else is actually marketing a product under what they've chosen as their company name, if they want to also use that name as their product. Okay. So trademarks protect your product name. They protect your brand. They also can protect things like slogans and logos, but it's basically anything that connects in the consumer's mind your good or service with you. So any branding, it can be a color, it can be a sound, it can be a smell. It's most usually a logo, a slogan, or a name, but that's what trademarks cover. That's the first misunderstanding. Second thing is that you need to be consistent about your trademark use, or else you can potentially weaken or even lose your legal rights. So consistent use of your branding, of course, is a good business strategy anyway, because what are you doing? You're building up brand identity in the mind of the consumer. So you want to keep using the same mark so that they continue to affiliate the goods and services under that mark with you. But you also need to do it legally, because if you start changing what you're doing with your mark, you change the picture of the logo, you add an exclamation mark at the end of that word mark, you add S's, you start changing it slightly. That's not what you have the trademark coverage over. You have the registration over the first way you were using the mark. And so you want to keep using it in the same way so that if someone else uses a similar mark, you can shut down their use. You don't want to lose your legal rights. Another good way to lose your legal rights is to start using your trademark as a noun or a verb. This is called genericide in trademark law, where basically, for example, Google is a very strong trademark. It's worth billions of dollars, but people often talk about Googling something. And if you were the Google trademark lawyer, this would drive you crazy, because you don't want Google to become a word, because you can't trademark anything that is generic or highly descriptive. So you want to be very careful if you want to build your trademark rights to only use your trademark as an adjective. not as a noun or a verb. This is Coca-Cola soda. You're not drinking a Coke. That's there are lots and lots of examples of trademarks that have gone through genericide. Escalator used to be a trademark. Aspirin used to be a trademark. So you want to keep Velcro right now has this huge ad campaign. If you want to chuckle at a bunch of nerdy lawyers, they actually have a YouTube video of their whole legal department doing a song, like a Broadway song and dance, about how they are the Velcro hook and eye attachment. They're not Velcro. Their product is not Velcro. Anyway, so you want to keep using your trademark in the proper way, which is to use it as an adjective. You should also mark your trademarks. If you don't actually have federal registration, you have the right to use the TM after your trademark immediately, just because you're using it in commerce. Once you get that registration, you can use that little R in the circle. And if you do that, it helps to put other people on notice that you have rights and that you intend to enforce them. And so even if you don't want to file a federal trademark registration, you should be using your TM just to show that you are, taking those rights seriously. And you should watch other people's use of your trademark. You lose the right to make an argument against somebody new if they are infringing your trademark, if you've allowed a whole bunch of other people to infringe your trademark without ever saying anything. So if you really do take your mark seriously, you should be monitoring other people's use of it and shut down that use. So trademark, this is about trademarks and how to keep your trademark strong. Questions about that? Okay, I know we're down to 7 minutes, so I'm going to be quick about lesson 8, 9, and 10 here. Third-party content. We get a lot of entrepreneurs that say to us, it's okay that I'm using what I know to be copyrighted content because I'm giving them attribution. So this worked when you were writing term papers in 4th grade, when you're doing footnotes. That's the proper way to operate when you're doing research papers. It is not excusable use in copyright world. If you're using somebody's content, even if you give them attribution, you are still infringing their copyright if you're displaying it or distributing it or copying it or doing anything that they have the rights to keep you from doing. So if you need to use third-party content, don't think that you can do it just by attributing it to somebody else. This goes for website use, this goes for product use, any way that you're using third-party content. We have this great law called the DMCA, which stands for the Digital Millennium Copyright Act, but you don't need to remember that. Basically, what you do need to remember is that the DMCA gives you an opportunity to allow third parties to post their own stuff on your site. And if they post copyright infringing stuff, you are not blamed. So if you are a tech company that is a platform and you're encouraging users to upload their copyrighted material and they are the infringers, you have a safe harbor under the DMCA as long as you take certain steps to maintain that safe harbor. If you want to know more about that, you should talk to counsel, or I'm happy to answer questions about it, but just know that there is a protection for you. Open source content, we get questions about this a lot. Open source content is basically content that's posted online that is to be reused. But just because it's posted online as open source doesn't mean that there aren't some restrictions off of it. People might post content and say, this is open source, but I really don't want you to use it for commercial purposes. Or this is open source, but if you use it, you have to attribute us. And the worst thing, this is open source, but if you incorporate it into your technology, you're promising you're going to make all that technology also available to everyone, open source. And that's where it gets really dangerous. Make sure if you are using open source content in your code or your technology, that you don't have a restriction on your further use. If you're building your whole company around the value of that software, and you incorporate somebody else's open source content that says that you have to give away all of your stuff for free, basically open source, how are you going to charge for that? So just be very careful when you're using open source. Sometimes just be intentional, but sometimes it carries some restrictions. Not news to anyone, but we are in a brave new world of privacy at this point. And terms of use and privacy policies are your friends as a tech company. Terms of use limits what users can do with your technology. And if you're worried about distribution or uses that you don't want for your technology, that's where you can contractually bind people not to do the thing that you don't want them to do. So you should have a terms of use. Privacy policies come into play when you are collecting information, not just, so terms of use is when people are using your technology, it protects you. Privacy policy is when you are collecting information and it protects the user. And the important thing to remember about privacy policies, first of all, they have to be relevant. You can't just cut and paste someone else's privacy policy if it is not really relevant to what you're doing. And they have to be updated, and they have to be written in terms that your user can understand. So if you are a tech company that is marketing to children, they need to be understandable to that age group, 12-year-olds. Okay, so privacy policies, it's helpful if you use a lawyer to draft them, because I think that there are a couple of gotchas in there, and the law is changing, every day. I don't think that's news to anybody on this call. And then finally, lawyers are your friends. I am a lawyer, so of course I'm going to say this, but we have seen all of these other lessons and more play out again and again and again. And there are ways that you can leverage lawyers, even on a small budget, to help you in outsized ways. How? Call in a lawyer when you have to do an important contract or an important registration. If your whole company is going to be based around this asset, don't you want it to be done correctly? Don't file your patents yourself. Check with somebody. Trademarks too, to a lesser extent, they're a little bit easier to file. But if you're all about branding and that's all you've got, do yourself a favor and hire someone to help you. To keep costs low though, you can do some preliminary research. You can do some prior art searching. You can provide information to the lawyer that's going to make their searching more efficient, and you can organize all of your documents. And best of all, tell your lawyer everything, even the bad stuff, the stuff that you're afraid of, the stuff you've discovered. I think a lot of entrepreneurs are in a mode, they're in sales mode a lot, and they need to be. So they're constantly asking for help. They want to attract funders. They want to attract customers. They want to show the world that they've got something great. That's not the way you should approach working with your lawyer. You need to tell your lawyer the things that you're worried about so that they can help you to mitigate risk and they can build your value. So turn off the sales mode, turn on, just open the kimono and let the lawyer be your partner. They're obligated to be under confidentiality. We try not to be judgy. We're just there really to help. So tell even the bad stuff to your lawyer. We know about some tools that might be really helpful for you. We can leverage things like provisional patents, intent to use trademark applications. We can fast track. We can solve a lot of your problems with less money if you tell us what's going on. We talked about disclosure, the poor man's patent. There are some continuations in part strategy that we can help you with if you end up patenting, and helping you to do your licenses correctly, I think is a great way to use lawyers to help you build value. So we are at time exactly. This is my last slide, but I'm happy to remain for those that can stay on the call for a couple of minutes if there are any final questions.
There is a question. Mindy, I don't know if you're still on the line, but she thanks you for the webinar, great content. She wondered if there's sort of a checklist that goes along with each of these areas. So in other words, you presented the 10 lessons. Is there a checklist that someone could tick off that they actually learned the lesson?
Not that I've created, but what a great idea for next summer. However, I am sure that there are. I just can't direct you to one. There is one IP audit reading that I assign my students that sort of goes through a lot of, it's directed to a lawyer, but basically says, have you asked the client this. And so maybe that's more or less what you're looking for. And I'm happy to send you that reading if you want to or maybe other people are saying thumbs up and and nodding. Mark, maybe I can provide you that reading, and you can post it or provide it to attendees if that's helpful.
Yeah, I think Nicole does a great job of following up with all the attendees. So if you give me that information link, we'll include it in our follow-up email to all the attendees.
Sure. It came out of some reading that I did at some point. So it is copyrightable or copyrighted, but I don't think you have to buy the whole book. I'm just happy to provide a link, and then,
Okay.
hopefully it's helpful.
I have one question that maybe we can go into or not. I don't know how detailed it is, but this is around fair use. And people say that some things that are published or available, you can use them in. There's some sort of fair use doctrine that says, you're immune from legal repercussions under this fair use criteria. What is that really? And is that a lot of smoke and mirrors, or what is that?
So I would not say it's smoke and mirrors, it's real, but it is very mushy. And I would never, ever bet my company on fair use. So what it is it is a defense to copyright infringement. So you use fair use when you are in court and you are trying to say, I should not have to pay all the damages that I have been sued for because I have a defense of fair use. So the first point I'd like to make is that you are in deep trouble if you're talking about fair use. So don't bank the value of your company on that, defense. But what it is basically is, policy-wise, we realize that there are certain times that people should be allowed to use copyrighted material. For example, if you are doing a news commentary, you need to say, here is the copyrighted material. Now I'm going to take it farther and I'm going to tell you what I think about that. So you can't, you can't set the context unless you have presented the copyrighted material. So that's one time that we will excuse copyright infringement, strict copyright infringement, because you are displaying or copying the original language in order to then respond to it. Same thing with parody. For people to get the joke, you probably have to show them the original, or you have to infringe potentially on the original in order to take it in a new funny direction. So we will excuse copyright infringement for parody purposes. We will also separately allow people to use copyrighted material in an educational setting and that truly is like students, teacher, university, or elementary school. Like it's not like educational setting like we are doing here. You're not my students. This is not a school. So this is not really under the fair use guidelines. So I guess what I'm saying is that fair use exists, it's real, but there are very specific times when it comes into play, and you run a risk at any point using it because a court may decide, yeah, actually, this really wasn't fair use. It's just copyright infringement. It's not excused. Okay. There's a 4-part test about whether or not something is fair use besides sort of the scenario that it's used in. It basically comes down to how much are you using? Are you using it for a commercial purpose? What are you using it for? And what was it to begin with? And so they sort of put all of this into a soup and stir, and then sometimes it comes out in the right way. So.
All right, well, thank you. I don't see any more questions on the chat list. So what I'd invite is any of the participants, if you think of a follow-up question, please send it to me, Kate, or Nicole, and we can get that to Cynthia and she can respond whatever method is great. We can post it as Ben Franklin, or it could be just a private response to a question. So if you have any, so please, if there's anything that comes up, let us know. We're always looking for feedback on our webinar series, ideas on new topics, things that we can do better, improve on. So anybody who's out there, please let us know what we're doing well and what we need to improve on. And finally, thank you very much to Cynthia. There's a ton of information. I'm glad it's recorded so people can kind of, they can go look at specific parts if they were overwhelmed with all that great content. So thank you so much. And thanks everybody today for participation. and look forward to another webinar, maybe 5 or 6 weeks from now. So thank you. Have a great day, everybody, and be safe out there.
Thank you, Mark. Thank you,
Thank you.
everyone. Bye.
Thank you.
Thank you. That was terrific.
Thank you.
Kate, are you still on?
Hey Cynthia, sorry to keep the say hi earlier. I was checking people in. How are you?
Oh, sure. I knew that you were busy. I could tell. I wanted to let you know that I added one slide, which was, you probably saw, but basically the picture of the clinic and my contact information and the website of the clinic. So I would like to follow up with a new version of the PowerPoint, if that's okay.
Oh yeah, to send out to everyone.
Yeah.
Yeah, perfect. Yeah, if you could just send that over. It usually takes us, you know, a couple days to get the materials out. So plenty of
Sure.
time.
Happy to send it out. And then I should look for that reading too and send it to you. That I think it's called the IP audit checklist. So I will look for that. We start class tomorrow, so I may get to it over the weekend, but I will definitely send it as soon as I can.
Oh, perfect. Yep. No hurry. Once you have it together, I'll let Nicole know and we'll plan to include that in our outlook.
Sounds good. I hope that wasn't too much. I got the sense from Mark that I put too much in there, but we can always sort of, anything that resonated with someone that they have more questions on, I'm happy to answer
Oh,
questions.
sure. Yeah, I think it was great overview, and especially with your office hours and this opportunity you have, I think a lot of people will probably take you up on that to follow up.
Good. Sounds good. All right. Thank you so much for making it happen.
Thank you. Have a great day.
You too.
Talk to you soon.
Bye-bye.
All right. Bye-bye. Bye, everyone.